Well, good evening and welcome back to AJ 101 Criminal Law Online. And tonight we're going to have our Chapter 2 lecture. And Chapter 2 covers the classification of crimes and penalties. So we're gonna take a look at a couple of different things here. We'll look at the language of criminal statutes and kind of how to interpret it. We'll talk a little bit about vagueness on some of the statutes and the fact that we really need to be able to understand what the statute's intent is, because that's very, very important. We'll talk about some terms, some definitions, so hopefully you did your terminology quiz in there. We'll look at the types of crimes, if you will, and how they're divided in California. Talk a little bit about some provisions of law and some of the legislative efforts that came forward in a couple of propositions like Proposition 8, Proposition 115, Proposition 47, and a couple of things like that. We'll look at some prior convictions, penalty enhancements, and then we'll end with talking about lesser and include offenses and this thing called Jeopardy. And that's not the game of Jeopardy. It's like when Jeopardy attaches, and I'll kind of explain myself a little bit more as we get going. So with that being said, let's kind of jump right into Chapter 2. So criminal statutes may not, by interpretation, be extended beyond their plain meaning. Unless common sense or the obvious purpose of the legislature so requires. So, when you read a criminal statute, you're urged to use the plain meaning of the written law, okay? Unless common sense would dictate otherwise, or again, obvious purpose of the legislature dictates otherwise. So knowing the intent of the law is very, very important. So in the interpretation of statutes or the construction of the words in such statutes, the defendant is entitled to the benefit of every reasonable doubt, just as he or she is as to questions of fact involved. So when we're going to err on the side of caution, if you will. Okay, and then understand that words from foreign sources sometimes take on their commonly understood meaning in our culture. So understanding the language of criminal statutes and being able to interpret it properly is very, very important. Now, there's a couple of cases that are in Chapter 2. One would be People versus Davis that might be good for you to look up that kind of explains things a little bit more. But again, we need to understand that we have to have some, credibility within the law, and in order to do that, we use, or continuity as well. We are to use that plain meaning of the law, unless there's another reason that we really, really shouldn't. So, along with that, we should understand that criminal statutes sometimes can be a little bit vague, okay, or indefinite. And that's one of the terms that you can see here on the slide, meaning not precise or exact, meaning that maybe it doesn't explain the whole thing. It might just have a kind of a meaning, but you don't get it. So the term vague, uncertain, unclear, unclear character or meaning, indefinite, not precise or exact. So these types of laws will typically result in a violation of the Due Process Clause of the 14th Amendment if we don't really expound on the meaning. So as an example here, we can look down and say, hey, words such as immoral or loiter, they have to be clearly defined in order to be constitutional, because let's face it, what might be immoral to you may not be to somebody else. Now, I'm not talking about severe, obvious criminal things, but I'm sure you get my meaning. The same with loiter. What does that mean? Think about that. If I said, hey, what does the word loiter mean? Well, does it mean just to stand around? Does it mean to stand around and do nothing? Does it mean to be in somebody's way? I mean, we have to define those in order to make things more clear. So that way, if we're going to use them in a crime, the defendant knows what it is. So again, words such as immoral, loiter, if used in a crime, really need to be clearly defined in terms of specific acts or actions in order to be constitutional. So that kind of spells it out. Hey, what are the actions that constitute this particular thing? Otherwise, as we've kind of talked about, such laws would be declared void as vague. And backing up for a second here, the 14th Amendment to the U.S. Constitution is super important, and I would suggest that you go through the PowerPoint that I posted on the Bill of Rights, which, although it is the first 10 amendments to the Constitution, I added in the 14th because it is very, very important, and a lot of these amendments are going to be woven kind of in and out of our discussions as it relates to criminal law. So again, please take the time to do that. Okay, so moving on. So let's talk a little bit about the construction of penal statutes and this thing here that they call the letter of the law versus the spirit of the law. And what does that even mean, and why do we even care? So the California legal system is in part based on the English common law system, okay? Even though we don't recognize it, it is. However, California jurisprudence law, okay, is less tied to tradition and more towards people-oriented than is the old common law. You see, common law is bound by the letter of the law. The California legal system is directed more toward the spirit of the law. The California legislature expressed this intent specifically in 1872 by enacting Penal Code Section 4, which reads in part, it's a little bit of legalese, but I'll tell it to you anyway, the rule of common law that penal statutes are to be strictly construed has no application to this code. All of its provisions are to be construed according to fair import of their terms with a view to affect its objects and promote justice. So, courts not only look at the literal meaning of words, but also the spirit in which the law was written and its legislative intent. What was it meant for? And that's when we dissect these, and when the courts dissect this construction part, that's how they kind of look at it. And when language can be interpreted in two or more different ways, we use that way which is more favorable towards the defendant, because that's kind of the only fair way to do it. And remember, California jurisprudence is kind of more people-oriented. So I kind of hope that makes sense a little bit. Now, there's another way of looking at the letter of the law and the spirit of the law that'll kind of help tie that in, although it's more like kind of officer jargon, but you'll get what I mean. So picture this as an example. The letter of the law, as in common law, okay, so we can kind of bring that in, is tied more towards like that written law. It's black and white. So if you do 65 and 60 is the speed limit, but you're going 65, the letter of the law says it's in black and white, you get the ticket for going 5 miles an hour over. Okay? But yet, if there's any doubt or whatever, the spirit of the law would say, well, maybe, okay, let's look at the literal meaning of the law. Yeah, you were going a little bit over, but maybe there was a rationale for why you were going a little bit over, not an excuse, if you will, but the flow of traffic or something like that. So officers kind of look at this letter and spirit of the law, not quite exactly the way that this construction of penal statutes looks at it, but hopefully you can kind of get that metaphor to where the spirit of the law is geared more towards people-oriented. Okay, so yeah, I think that'll kind of get it. But real quick too, and I hate to back up, but I'm going to do it anyway, just just because. Let me back up here for a second. When you look at this vague and indefinite statute things, I wanted to kind of throw a section in there that's a little bit, we talked about loitering, right? It's kind of vague. What does it really mean to like loiter? There's a section in the penal code that I'd like you all to look up, and we'll have a discussion on probably. It's 261.5. And when you talk about looking at the intent of the law, okay, so 261.5 of the California Penal Code is in its simplest form is what they call statutory rape, which is basically an 18-year-old having sex with somebody under 18. Picture this as an example, okay, and then maybe this will start to sink in a little bit better as a good example. Let's just say that the young lady is 18 years old and the young man is 17 years old. Now, technically, by statute, 261.5 basically says that is statutory rape, and the woman could be arrested for that because the young man is a minor. But is that really what the intent of the law was? So there are sometimes, there will be prosecutors or attorneys that may not prosecute on that grounds because we know that sometimes kids of that age tend to do those types of things. And is that really the intent of what the law was? Or was the intent of the law to safeguard those younger kids from those older folks that might be wanting to do them some type of harm or what have you? You get my meaning? So I just kind of threw that in there to get your juices flowing a little bit as we talk more about some of the different statutes and things like that. So what happens then, as we kind of move on, when things kind of conflict, where two laws basically conflict? So where two state laws punish exactly the same act or omission as crimes, and they are obviously in conflict, the last one passed into law will control that. That's People versus Jones, and it's down there for you to look at. Now, the term conflict between statutes, don't confuse it with the concept of preemption described in section 1.11 in your textbook, okay? The concept of preemption means that state laws take priority over city and county ordinances. Conflict between statutes refers to conflicting state laws, okay? So on an even keel, if that kind of helps a little bit. So a couple of important terms that you need to know. You can find in Penal Code 7, and hopefully you did your terminology quiz. The one that you're not graded on, but at least you'll be able to know what some of the terms are, and I think that's really good. So willful, a purpose or willingness to commit the act. Negligent, a want or lack of attention to the probable consequences of the act. Malice, to vex, annoy, or injure another person, or the intent to do a wrongful act knowingly. Only the knowledge that the facts exist. Doesn't require any knowledge of unlawfulness. Okay, this is kind of a state of mind thing. Does not require intent. So these are important terms that you're going to see again as we start to look at a couple of these different things, and you'll totally you'll get what I'm talking about a little bit more. Now, some of those other definitions, when you look in your book in chapter 2, page 20, section 2.5 talks about some other terms that are in there that I would suggest that you know. So know some of those terms, and I think it will help you quite a bit. So now we'll move on to some other cool stuff: felonies, misdemeanors, and infractions. So these are the kinds of crimes. So they're divided in California. They're divided into 3 categories. Penal Code 16 says so that's why we're talking about it. Felonies are serious crimes punishable by death, state prison, or county jail for a felony term, whatever that term is. And some of the terms are actually listed in the section, like how much time you'll get. And we'll talk a little bit more about that. A felony could be like burglary or auto theft or felony assault or domestic violence type things, or rape, murder, robbery. Those are felonies. Okay, misdemeanors, a step lower, moderately serious crime punished by county jail and or fine or both. Penal Code 17 could be like petty theft or DUI, driving under the influence, or vandalism or something like that. And then the final one, the lowest level, would be an infraction. Least of the three when it comes to serious crimes, punished by fine. The only difference is, and kind of take note of this, that for an infraction, there's no right to a jury trial or a public defender. Okay, for a misdemeanor and felony, you can have that. For an infraction, you don't get that. And typically an infraction is a traffic ticket. So you're not entitled to a jury trial, and you're not entitled to a public defender when it comes to an infraction. Okay, so some other codes that we're not going to spend a lot of time on, but they are in your book, and you should kind of know them. And a lot of these, I think, are on page 22 and page 23. So Penal Code 16 talks about the kinds of crimes. 17 talks about the classification. We just kind of spent some time on that. 18 talks about prison versus jail and wobblers, and we'll get to that in a minute. 19 is the infraction trial by court limitations. And you can kind of see how this goes all the way through. All the way down to Penal Code 296, which talks about DNA database specimens. So I'll go a little bit on this one, a little bit deeper, because it is important. And there's a case law called Maryland versus King that's super important that you remember, because you will see this case law again. I don't know if it'll be on your research paper or on a discussion board project, but it is going to come up again, and it's big time important. So persons convicted of enumerated crimes, meaning those listed in the penal code, are required to provide 2 specimens of blood, a saliva sample, right thumbprint, and full palm prints of both hands for inclusion in state databases. The specified crimes include, and here's some that I'll give you: registerable sex offenses, murder, voluntary manslaughter, felony spouse abuse, aggravated sexual assault of a child, felony assaults and battery, kidnap, mayhem, torture, first-degree burglary, robbery, arson, carjacking, terrorist activity. These are some, if not all. And the Supreme Court ruled that as part of a routine booking process, when the person is arrested and goes to jail, part of that booking for serious offenders, the officers may take what is known as a buccal or buccal, whichever way you want to pronounce it, buccal cheek swab for DNA for database purposes. So that's the Maryland versus King case. And again, I think it's really important that you kind of know that. But kind of go through your book a little bit and look at some of these things that are in there. Again, some of these kind of important sections to know that it'll help you later on. So wobblers, what is that? So it's kind of a new thing. New thing as far as like what we're talking about today. So some crimes can be punished as either a felony or a misdemeanor. This is known as a wobbler crime. And some crimes provide for an alternative sentence, and they're punishable by either as a felony or a misdemeanor. Such crimes are commonly called wobblers. Sometimes a wobbler filed as a felony will be reduced to a misdemeanor by the judge at the preliminary hearing. Sometimes the prosecutor will file a wobbler as a misdemeanor from the beginning. However, unless filed as a misdemeanor or reduced to such at the preliminary hearing, wobblers are otherwise considered felonies for all purposes. So an example would be like this. So a person may commit an offense such as burglary in the second degree, Penal Code 459, which is a felony, but which may be designated a misdemeanor, okay, at the discretion of the prosecutor at the time of charging or by the court, okay, or by the court after the preliminary hearing or at sentencing. So you have a little bit of discretion there. Also, because some felony wobblers are punishable by state prison and others by incarceration in county jail, there are both prison wobblers and jail wobblers. So just so you kind of know that as well. So that's kind of the overview of what a wobbler is. We won't go into super, in depth on this, but again, at least you have a decent idea of what it is. So punishments not for offenses, or punishments for offenses not otherwise prescribed. You can find it in Penal Code 18. So except in cases where a different punishment is prescribed by any law of the state of California, every offense is declared to be a felony or to be punishable by imprisonment in a state prison or county jail, is punishable by imprisonment for 16 months, 2 years, or 3 years, and the section kind of goes on. So the reason I keep going back to this, where we talk about things that you need to read, there's a lot of nuances in the law. Okay, so so that was the first one, felonies when not otherwise prescribed. So another example would be like maximum term for misdemeanor. So what does that mean? Well, except where a different punishment is prescribed for a misdemeanor, it is punishable by imprisonment in the county jail not exceeding 6 months, or by a fine of $1,000, or both. So this is section 19, and then you'll see down here section 19.2 for consecutive sentences. And that's why I'm kind of keep going back to it, telling you guys, hey, just kind of read some of these small little sections in there, so you really kind of understand what it's coming to. Misdemeanor offense, jail term not to exceed 364 days, Penal Code 18.5. So that's another one that you should probably kind of understand. But we'll talk more about some of the penalties and things a little bit later on. But keep an eye on these other sections that are there. So initiative measures, and this is important because we want to make sure that you know that things can change. Okay, and initiative measures, they're petitions signed by a certain minimum number of registered voters, and in turn, that can force a public vote on a proposed statute or constitutional amendment, which can actually cause some type of change. And that's kind of the rationale for that, how legislation can change things. So in California, a couple of propositions, and it says 2, but it really should be 3, but in California, 2 such, or 3 because I added the third, propositions to amend criminal laws and procedures are Prop 8, which was 1982, Prop 115, which is 1990, and most recently Prop 47, which was in 2014. So, there were a lot of different things that happened when it came to Proposition 15 and even Proposition 8. And I'm not going to go into detail on those. But it made some changes, and some of the changes that kind of extended from Proposition 8. Prop 115 made a number of procedural changes, kind of aimed at reducing delays and inequities in the processing of criminal cases, and some of it was limiting voir dire or jury selection, or permitting qualified officers to testify on hearsay at preliminary hearings, and just a bunch of different things. Granting limited discovery rights, access to evidence, things like that. Prop 47, the most recent one, okay, ballot measure known as Prop 47, was approved by the voters and became effective November 2014. The effect of the proposition was to reduce the seriousness of a number of crimes, both as to future prosecutions and as to those already convicted. So basically, it reduced some felonies to misdemeanors. And some of you are probably going, well, why would we even do that? Well, a lot of times propositions are kind of based on the pulse of your community and how we are feeling as a community and what we kind of expect or maybe even what other states are doing. And when it reaches that level, a certain number of registered voters can basically push it to a public vote on kind of altering, if you will, a statute or a constitutional amendment as well. So, so an example for Prop 47, let's see, what would be, here's a good one. Personal possession of certain drugs, such as heroin, cocaine, concentrated cannabis, and methamphetamine was reduced from a felony to a misdemeanor. Okay. Now, some of you are going to go, why would we ever do that? Well, is it because we have so many people that are getting arrested for just personal use? And because of the amount, we don't think it should be a felony? I mean, these are things that you have to think of. So if you look on page 27 in your book under section 2.10, it will give you a list of those things that were changed under Proposition 47. So that was just one thing where they reduced what was always before any amount of personal use of those drugs that I just talked about was a felony. However, now personal possession of certain drugs, the ones that I listed there, are now a misdemeanor. So just kind of keep those things in mind too, and now you know kind of how things change. Here's a list of major Proposition 8 and 15 changes. I kind of went over some of them, but it impacted certain things. These two propositions, the changes, rules of evidence, bail provisions, the use of prior convictions. It actually got rid of diminished capacity as a defense. Diminished capacity, just to kind of give you an idea of what it is, the defense of diminished capacity basically under this section now is abolished in a criminal action as well as in juvenile court proceedings. And people would actually use this as a defense while we're basically saying, no, we're not going to use diminished capacity anymore. So because of the changes in 8 and 115, that was abolished. The insanity defense talks a little bit about in criminal proceedings, including any juvenile court proceeding in which a plea of not guilty by reason of insanity is entered, the defense shall be found by the trier of fact only when the accused person proves by a preponderance or a greater weight of evidence that he or she was incapable of, 1, knowing and understanding the nature or quality of his or her act, or 2, distinguishing right from wrong at the time of the commission of the offense. So, again, things are kind of, some changes were made in some of the procedures and things that we were using. So now kind of moving on a little bit, and we'll talk a little bit about prior conviction penalty enhancements. So there are some changes. Petty theft. It used to be that if you had a prior conviction with petty theft, you could make it a felony. Prop 47 kind of changed a little bit of that. But there are enhancements for those who are armed and use a firearm. Prior serious convictions, prior felony convictions outside of California, violent felonies, habitual sex offender. All of these are prior conviction penalty enhancements that can be added on for whatever particular crime that we're talking about. And you'll find a lot of that in Chapter 2 on page 28, and you'll be able to see kind of how those are. I can give you an example if you want. So violent felonies, so we'll look down the list here. We'll just pick one. Penal Code Section 667.5 provides that a consecutive and additional 3-year prison term shall be imposed by the court for each prior term served for a violent felony within 10 preceding years, and upon conviction of a subsequent felony as listed below. So, and then they have all of those felonies that are included in the section. So that would be an enhancement. Okay. You look up here, prior federal convictions. California will consider most prior federal felony convictions for this purpose of increasing the severity of an offense as long as such federal offense would be a felony under California law. So you can see that all of these little things are enhancement. We'll do one more just to kind of give you an idea. Armed and use. Sentences for specified felonies are increased by consecutive terms ranging from 1 year to life in prison, where one or more principals were armed with, used, or discharged firearms with resulting injuries. In some cases, even an unloaded and inoperable firearm can support sentence enhancements, and greater sentences are also prescribed in gang cases. So you can see that these are things that you can add on, if you will, okay, when you talk about enhancements. Another one here, prior convictions. California Department of Juvenile Justice, any person 18 years or older at the time of the commission of any crimes listed in Penal Code 1192.7, and there is a list there, is not eligible for commitment to the California Department of Juvenile Justice. These include murder, rape, or any other serious felony. Okay. So that kind of brings us close to the end here. We'll talk a little bit about lesser and included offenses, and we'll almost be wrapped up. The jury, the judge, if it's a jury trial, if the jury trial is waived, may find the defendant guilty of any offense, the commission of which is necessarily included in that which he is charged, or of an attempt to commit the offense. Penal Code Section 1159. Well, what does that actually even mean? So let me kind of explain it, because that's like super legalese. In California, there are several offenses, okay, the commission of which necessarily includes other lesser offenses. However, before a lesser offense may be said to constitute a necessary part of the greater offense, all of the legal elements of the lesser offense must be included in the elements of the greater offense. And again, you know, hopefully I'm not steering you like way out there. So that's People versus Greer. So for example, every battery, which is a misdemeanor, includes an assault. But a battery is the greater of the two offenses. Okay? Penal Code Section 1159 states that the jury or the judge, if a jury trial is waived, may find the defendant guilty of any offense, the commission of which is necessarily included in that with which he is charged, or of an attempt to commit the offense. So let me give you another example and try to like, so here's an example of lesser and included offenses. Simple assault. The crime of simple assault is necessarily included in the crimes of battery, mayhem, assault with a deadly weapon, spouse beating, rape, robbery, and sodomy with force. Petty theft is necessarily included in the crimes of grand theft and robbery. Okay? Is everybody kind of picking up on where I'm going with that? So here's some examples of lesser offenses not included. The crime of robbery does not include the offense of receiving stolen property, nor is the offense of child molesting necessarily included in the crime of oral copulation. And I know it's kind of tedious, but that's kind of the law. And that's why you need your book. Okay? But it all comes down to the little square that you see at the bottom of the slide here. A person may not be convicted of a lesser related offense that was not necessarily included in the charged crime. So the good example out of here would be the robbery case. So if I rob you, after I rob you, I have stolen property because I robbed you of it, but you can't, it doesn't work, it doesn't go back that way in the robbery. So the crime of robbery doesn't include the offense of receiving stolen property. But on the other example I gave, the crime of simple assault, or we can go with petty theft. The crime of petty theft is necessarily included in the crimes of grand theft and robbery. So we'll talk more about this, and we'll try to kind of chew it up a little bit so you understand it a little bit more as we go on. But read your terminology thing. And then finally, we're going to end with this, and then we'll be done with chapter 2. So it's this thing called Jeopardy, and it's not the game show. It's a principle. The basic principle in the law of former jeopardy, okay, kind of bear with me, is that the person who has committed a criminal act shall be subject to but one prosecution for that act. When that prosecution has resulted in a final judgment of conviction or the defendant has been acquitted, the defendant cannot be prosecuted again for the same crime. Even if there is no formal verdict or finding that the defendant is not guilty, if jeopardy has attached, and that means when the jury is sworn in at a jury trial, you need to know that part, or when the first witness is sworn in a court trial, you need to know that part, no subsequent prosecution of such defendant can be had for such act. Furthermore, a conviction by plea of guilty is a valid conviction which will bar a second prosecution. So here's an example. I'll try to kind of like make it simple here. A burglar cannot usually be convicted of both receiving stolen property, his or her burglary tools, and burglary. Okay, and there's a couple of cases that kind of hold that. Okay, so I'm not sure if that kind of sunk in, but they call this the lesser and included offense, and you know that's the lesser and included offense part, and then they talk about jeopardy attaching. So let me finish this thought up here. In essence, the jeopardy rule prevents a second prosecution for either the identical offense involved in the first trial or for another offense based on the act constituting the offense charged in the first trial. Furthermore, a defendant cannot be prosecuted a second time for an attempt to commit such an offense, nor for any offense necessarily included therein, nor for a crime in which such offense is necessarily included. Penal Code 1023. A super lot of legalese. I would suggest that you look at the case U.S. versus Dixon, where the Supreme Court held that double jeopardy clause doesn't apply to, you know, a couple of different things. That'll kind of help you look at some of the stuff. There's a couple of other cases that are important. People versus Jaramillo, and that's Jaramillo, and People versus Hansard, Hansard. Both of those talk about when jeopardy attaches and what have you. Now, don't get this confused a little bit with you know, having a second trial and things like that. We'll talk more about that, and to kind of clear that up, that issue up a little bit. You know, you can't be tried for the same case if there is a proper disposition. So an example would be if you get arrested for burglary and you're in a jury trial and they find you not guilty or you're acquitted, they can't try you for that same case. All right? But if they, same case scenario, you get arrested for burglary, we got a jury trial, and the jury is deadlocked. They can't decide, so there's a mistrial because they just can't come to a verdict. There's no guilty, there's no not guilty. They can't figure out the answer, which would be a mistrial. The prosecution does have the discretion to try that case again because there was no finality to that disposition, if that kind of makes sense. But that's kind of a different animal than when jeopardy kind of attaches in that jeopardy principle. So anyway, I know that was tough, but hopefully you'll kind of get it a little bit as we talk more. Double jeopardy, double punishment. Finally, wherever possible, all related offenses from a single criminal episode will be charged in a single accusatory pleading and be simultaneously prosecuted. Collette versus Superior Court, so you have some information that you can kind of like dig in if you want to know a little bit more. Double jeopardy prohibition applies to prosecutions, not arrests. So there you go. A lot of information, a super lot of stuff. Please do your terminology quizzes, which again, they're not graded, they're there for you, and I will post the answer. So when the weeks open up on Wednesday, at 5 p.m. When you go into the content folder, you'll see the terminology quiz. Download it. Go through your book. Try it. Try to get all the answers right. Get your terms and your definitions together. And then on that Friday, I'll post the answers so you can kind of check yourself and see where you're at. Don't be the one that just waits until I post the answers. Do me a favor. Try to learn some of the terminology in there, okay? That's it. Until next time. And if you have any other questions, don't forget, I have a general discussion board where you can post questions or what have you. Either I'll answer it or perhaps another student will jump on and answer it. If you need anything else answered and you don't want anybody else to know about it, then email me directly at wfarrar@msjc.edu, and I'd be happy to answer all your questions. And that would be it for Chapter 2. See you next time.